Assalamualaikum and a very good day. I speak to Dr. Mukris. We are from AFARANI and Associates. We'd like to present on the topic of initiation of proceedings, the power of magistrate to take cognizance of an offence. Without further ado, let's go on to the question. So the question that we got is that magistrate may take cognizance of an offence upon receiving a complaint that some person has committed or is guilty of an offence. So explore whether the application for him to take such cognizance be refused. So the issue is that whether a magistrate can refuse to take such cognizance upon receiving a complaint that someone has committed or is guilty of an offence.
Criminal Procedure Code is silent about the word cognisance. In the case of PP against Leonard, Thompson judge held that cognisance means initial decision taken by the magistrate when there is a complaint be made to him against the suspected person that he need to look into. So it means that cognisance will include the intention of initiating judicial proceedings against the suspected person in respect of the offence and the steps to see whether there is a basis for initiating judicial proceeding or for other purposes. The power to take cognisance is based on magistrate discretion. If we look into section 128, subsection 1 of CPC, it authorizes the power to the magistrate to take cognisance. However, the word may here is an expression of possibility, which ordinarily implies the discretion, contrary to the word shall, which means mandatory provisions. So it can be said that magistrate has a power to take or refuse the cognisance of the offence. Section 128, Section 1 of the CPC lists a condition that need to follow by the magistrate before he can take cognisance of the offence. So the first one, magistrate may take cognisance when there is a complaint being made to him by the police officer concerning the non-seizable offence. And the second one, he may take cognisance when he is in knowledge or suspicion that the offence has been committed. When this situation happens, based on Section 128, Section 2, the case must be heard by another magistrate. And the third one is in the case of seizable offence, the magistrate can take cognisance when the public prosecutor required him to do so. And the last one, within his jurisdiction, the magistrate may take the cognisance when the police officer could not complete the investigation within 24 hours. In the case of Tan Howard against public prosecutor, it can be said that before a magistrate can take cognisance of the offence, he must be aware the type of offences that had been complained to him. In non-seizable offence, the complaint must be made by the police officer or private individual. And in the case of seizable offences, it must be required by the public prosecutor himself for the magistrate to inquire into the offence.
I'll be talking about the limitations of taking cognisance by a magistrate. So according to section 129 subsection 1 of the CPC, it restricts the magistrate from taking cognisance in certain cases for the offences under the penal code, like contempt of the lawful authority of public servant, offences relating to false evidence, offences against public justice, offences relating to documents and to currency notes and to bank notes unless complaints has been made by the public prosecutor. Next, according to section 130 of the CPC, no court shall take cognizance of any offence punishable under chapter 4 of the penal code, which is an offence against the state, except section 127, or punishable under section 108A, 298A, and 505 of the penal code, unless upon complaint made by the public prosecutor or any officer authorized by him in that capacity. The other two limitations of taking cognisance by a magistrate can be seen in section 131 of the CPC, where the court shall not take cognisance of an offence falling under the Penal Code Chapter 19 or Chapter 21 or sections 493 to 496 unless a complaint has been made by the public prosecutor. Next, section 132 of the CPC states that the magistrate shall not take cognisance of an offence under section 498 of the Penal Code unless the woman's husband files a complaint. It should be noted that section 422 subsection B of the CPC states that lack of sanction from public prosecutor does not render a charge illegal or a trial of an offence nullity unless such error, omissions, or irregularity has caused a failure of justice. The procedures to dismiss a complaint by a magistrate can be seen in section 135 subsection 1 of the CPC, where a magistrate hearing a complaint may dismiss the case if he believes there is insufficient ground for further actions after doing the necessary steps as required under section 134 of the CPC. And lastly, the procedure to dismiss a complaint by a magistrate can be seen in section 135 subsection 2 of the CPC, where the magistrate must then record his reason for dismiss the complaint. Lastly, I will talk about two cases, which is Lim Tian Huat against Foster 1974, which is the fact of this case is that the appellant filed a complaint to the magistrate regarding the accused who has committed an offence under the penal code, which is intentionally using force. But the magistrate did not do anything, so the appellant obtained a mandamus order to direct the magistrate to hear the complaint. So it was held that the appeal was dismissed because the land magistrate has considered all the materials and he had given due consideration to the complainant's statement and given his reasons for dismissing the complaint. Next, I will talk about the case of public prosecutor against Syarikat Tekala Sdn Bhd 2007. So in this case, the court states that the magistrate can only take cognisance unless there is a complaint made by the public prosecutor by way of writing as stated under section 1 to 9 subsection 3 of the CPC. So the way of writing can be in any form, such as sanction, consent, or written authority.
Hi, so we continue our presentations for today by discussing about the issue regarding the magistrate's power of cognizance. So the issue highlighted is whether the magistrate can refuse to take cognizance on offence committed or not. So by virtue of section 129, section 130, section 131 and section 132, it is said that the magistrate may refuse to take cognizance on offence committed. Section 129 mentioned that a magistrate cannot take cognizance of offences except in the case complaints laid by the public prosecutor, wherein in section 130 it is said that the magistrate may refuse any offence that is punishable under the penal code except section 127 or punishable under section 108A, 298A or 505 of the penal code. Meanwhile, section 131 and section 132 also listed an offences where the magistrate may refuse to take a cognizance. In section 131, it is said that offences listed under section 493 to 496 of the penal code, unless the persons aggrieved by the offence or public prosecutor may make a complaint. So in section 132, it is concerns about the offence of enticing, taking away or detaining with criminal intent a married woman under section 498 of the penal code unless the husbands of the woman make a complaint. Moreover, in section 135, it is about the power of the magistrate to dismiss the case. So the magistrate is given the power to dismiss the case if he found no sufficient ground for the case to be proceeded against the suspected person and list in the first information reports. But however, the dismissal should be entailed or enclosed with a report of reasons why he decided to dismiss the case.
I would like to continue the presentation with discussion on cases related to sections 129, 130, 131, 132, and 135 of the Criminal Procedure Code. In the case of Datuk Mahinda Singh, the appellant was charged with 2 offences of abetment under section 193 of Penal Code and no sanction in writing of the public prosecutor. Appellant's counsel argued that the court cannot take cognizance of offences without the previous written sanction. The court held that a written sanction of public prosecutor was necessary. The sanction needs to be a previous written sanction and it will not be implied with the mere presence of a deputy public prosecutor at a trial. The court opined that the opening words of section 129 subsection 1 of the CPC are clear. In the case of Ahmad Nizamuddin bin Setapa, the appellant was charged under Immigration Act. The court in deciding this case referred to the case of Tan Ho Wat, which decided that sections 129 and 130 limit the power of a private person to prosecute in criminal cases personally. Another case related to section 130 is the Long bin Samad case. It was held that the law intends to provide a wide discretion to the public prosecutor, which can be seen in section 130 of CPC, which rendered for the prosecution of certain offences, the public prosecutor's complaint is needed. In the case of Nai Prasik, the appellant was charged for bigamy under section 494 of the Penal Code. A police officer made a complaint which initiated these proceedings. Upon revision, the High Court decided, among others, that the Sessions Court cannot take cognizance of this offence since not the person as needed by section 131 of the CPC who are the person aggrieved or the public prosecutor, but police officer who made the complaint which initiated the proceedings. In the Rasia Munusami case, the complainant contended that the accused enticed his wife away from him for illicit intercourse and kept her in a hotel by deceit. It was held that where a complaint is made by the complainant who was her husband, the very first thing the magistrate must do upon receipt of the complaint is that the magistrate has to proceed immediately under section 133 subsection 1 of the CPC. Move to the last case of our discussion, the Lim Tian Huat case, which mentioned earlier by my groupmate. The appellant filed a complaint to magistrate. Later, he also obtained a mandamus order directing the magistrate to hear the complaint. The learned magistrate had considered all the materials, given due consideration to the complainant's statement, and given his reasons for dismissing the complaint.
In conclusion, a magistrate can or may refuse to take such cognizance when he receives a complaint that someone has committed or is guilty of an offence if it falls within the limitation prescribed under section 129, 130, 131, and 132 of Criminal Procedure Code as explained by my friends just now. Also, we know that this taking of cognizance upon an offence is actually based on the discretion of the magistrate after he has taken enough and sufficient considerations based on the investigation. So if he feels that there is no sufficient ground to proceed with the trial, then he won't take cognizance upon that offence. So I believe that is all from us. Thank you.